How are you today?
I'm good. How are you?
Good, thank
Morning,
you.
Judge Wallace.
Good morning. Good morning, Council. Welcome to an oral argument session for the 5th District Court of Appeal. My name is Rand Wallace. I am presiding here today. I also have joining me on the panel Judge Jim Edwards from Seminole County and Judge John Harris from Brevard County. We have one case on the docket here at 10 o'clock, and that is Joel Gonzalez versus the state of Florida. And I will assume, Mr. Pannell, that you want 5 minutes of rebuttal unless you tell me differently.
5 minutes is good.
Okay. And so with that, you may begin.
Good morning, may it please the court. My name is William Pannell and I represent the appellant Joel Gonzalez in this case. There's three important facts, I believe. Initially, Mr. Gonzalez's first trial resulted in a mistrial because the jury could not reach a unanimous verdict. Secondly, the alleged victim in this case, there was a 14-year delay between the alleged conduct and her reporting it to law enforcement. And third, there is no eyewitness, forensic, or scientific evidence corroborating the alleged victim's allegations against Mr. Gonzalez. So it's our position that this was a close case where the state did not present overwhelming evidence of Mr. Gonzalez's guilt. Under the facts of this case and based on the issues we raise on appeal, it's our position that it's impossible for this court to have confidence in the outcome of the trial. There were three different officers of the court who had a duty to act in a manner that would ensure that Mr. Gonzalez received a fair trial, and all three of those individuals failed to do so. The prosecutor, the trial judge, and Mr. Gonzalez's trial attorney in this case. The prosecutor violated the trial court's order in limine and made numerous improper arguments during closing. The trial judge failed to enforce his order in limine and failed to intervene when the prosecutor made improper arguments. And Mr. Gonzalez's own trial attorney failed to make the appropriate objections. We suggest that this case is analogous to this court's decision in Rodriguez back in 2017, where it reversed a lewd and lascivious molestation case and pointed out deficiencies on the part of trial counsel, the prosecutor, and the trial judge. Initially, prior to the trial in this case, the trial court granted Mr. Gonzalez's motion in limine prohibiting the state from introducing any evidence that he had committed or there had been allegations that he committed any prior criminal offenses.
That's not exactly what the order says, is it, Mr. Pannell?
I'm sorry?
The order was there'd be no evidence introduced that the defendant engaged in prior incidents of sexual battery. Isn't that what the judge actually ordered? And there won't be any reference to any prior convictions that he had.
Well, the motion was broader than that, and it was granted.
We're talking about what the order is. Did the state violate the order, not the motion?
Well, I believe they did. I mean, the order was any prior or other alleged instances of sexual battery, and then they introduced evidence in a controlled call that he had gotten in trouble for having sex with a young girl. I think it's a fair inference that that's criminal activity and evidence of sexual battery.
Are you talking about the interview with the police officer where he talks about it at one point, Mike, and it's unclear? I can let you in on something that we've all listened to the tape. I'm not sure if you had the opportunity to listen to the tape or not, but it seems, at least to me, and you correct me if I'm wrong, that's why we're all together here.
Sure.
It sounds more like he's talking about a fellow named Mike. I mean, there is a point there where initially I couldn't tell if it was Mike or I, but when you listen to the context of the entire call, he's talking about Mike, who's a sexual predator who got arrested back in 2001 and so forth. How is that incorrect?
Well, certainly on the pages 399 and 400 of the transcript, there's some.
I'm talking about the tape.
No, I
jury
understand.
heard the tape. The jury didn't get a transcript. The jury got a tape. They heard the tape.
Of course, I've listened to the tape, and I think it's fairly conceived as it could be the word "I" as well. And the sentence preceding it says, quote, I was living on 38th Street and Jesse was living in Point Siena. And then after that, that's when, quote, either I or Mike, and I think it's fair to conclude that it was I.
Well, I think if you stop there, I don't disagree with you. I think if you stop there, it was very confusing to me. I agree with that, but then you go on and whether you read or listen to the rest of it, it's talking about Mike getting locked up and so forth. It's not I got locked up, it's Mike got locked up.
I certainly agree with the court that he goes back and forth between talking about himself and Mike, but again, even if there's any possibility that the jury thought he was talking about himself, it's highly prejudicial. If it's not clear to the court and it's not clear to me, then it's not clear to the jury, and they may have concluded because they weren't correct.
I want you to be sure you understand. I'm not saying the overall thought wasn't clear. That one small segment when he says Mike, I couldn't tell if he was saying Mike or I or saying Mike and I, but again, just in fairness to you and your client, what I heard, if you listen to the whole thing, was he was clearly talking about Mike, but we don't need to belabor that point.
Sure. Because I think there's some chance or legitimate chance the jury interpreted it that it was him, that there was significant prejudice here. It violated the order of limine. Even if it didn't, its introduction was fundamental error, or alternatively, it was ineffective on its face for trial counsel not to seek a conclusion of that from the recording. There's no scenario where
you'll agree there's nothing in the motion in limine or the order granting the motion in limine about where he bragged about having 7 children with 6 different women, correct?
I agree with that.
Okay. And how about with regard to the domestic violence incident or case or proceedings or whatever he said with another woman? That wasn't directly brought up in the motion in limine or the order in limine, was it?
Well, the motion in limine broadly says no prior alleged criminal conduct. I think
we don't really know. I mean, that's kind of taking it an inference on an inference that the jury would think because there was a domestic violence thing that it was him and also that it was criminal.
Sure. The obviously the sexual allegation is the most egregious and the most prejudicial, but certainly when now you start adding evidence that he was involved in a domestic violence dispute and he had to move his residence, I think the jury could clearly infer that he was potentially the person who got in trouble for committing domestic violence.
Mr. Pinal, you keep talking about what was in the motion in limine. Why do we care what was in the motion? I mean, you're arguing on appeal that it was violated. The judge's order was violated. All the judge ordered is no evidence of prior incidents of sexual battery and no prior convictions. There's nothing about any prior alleged criminal conduct that's in the order. I grant you it's in the motion in limine, but the judge didn't order that, so why do we care?
Because I respectfully disagree with the court. I think on page 198 of the supplemental record, the court says, all right, then the motion in limine, which was filed on February 22nd, 2019, will be granted. And then he goes on to specifically say no evidence of sexual battery, but he doesn't limit which parts of the motion in limine he's granting. So I think he's granted in its entirety. And the state doesn't dispute that. So there's no, I just respectfully disagree with the court that the whole motion wasn't granted. Nonetheless, all this evidence was improper, is inadmissible. It's improper character evidence, improper propensity evidence. The evidence of the sexual battery or the conduct with the young girl, sleeping with a young girl, was particularly prejudicial. This court in Downs and Fike has repeatedly said that there's a commonly held belief that individuals who commit sexual assaults are more likely to recidivate, and that the admissions of prior acts of child molestation.
It seems to me when your client was talking about that guy Mike, he was trying to put it off on Mike that, you know, she let this sexual predator hang around the house and this, that, and the other. You know, I think he was trying to maybe put the police on the trail of Mike, so there may have been a reason for that. We don't know. We haven't heard.
I'm a little stronger on my feelings on this. I think Judge Edwards is. I think it's crystal clear that the reference was just to this Mike Kelly guy. He says that's when Mike had gotten in trouble for sleeping with the young girl. So it seems crystal clear to me that he didn't say I, but that, you know, I'm just one.
Okay. So it's our position that cumulatively, all the improper conduct was covered by the order of limine, but even if it wasn't, it should have been objected to by trial counsel. There's no good reason not to object to any of this evidence. I can't think of any reasonable strategic reason you want the jury to hear these things. Additionally, during closing argument, the prosecutor, we believe, committed several misstatements or incorrect arguments, starting with the appeal for justice in reaching the verdict. It's our position under Cardona and this court's decision on Rodriguez that reduces the burden of proof. And
those two cases are not this case. I mean, the justice for Lazaro or Lazaro in Cardona and in Rodriguez, it went well beyond that. I mean, here the prosecutor uses the word justice, I think, twice. And it's, quite frankly, who wouldn't want the state to be in pursuit of justice? And it's not justice for the victim. Here's what justice is for convictions. That's it. It's not asking them to convict on anything other than the burden of proof, is it?
I think it is, Your Honor. I think the term justice is not defined for the jury. I think that, if the jury's 60% sure that Mr. Gonzalez is guilty, they may think that's justice to rule in favor of the state. So I agree with you that the situations in Rodriguez and Cardona were more egregious, but cumulatively, all the errors in this case deprived Mr. Gonzalez of a fair trial. I point to the Cardona decision, and they cite the Edwards case from the 3rd DCA. And in that case, the prosecutor said, "I asked for justice on behalf of myself and the people of the state of Florida, and also on behalf of the victim's wife and child." So they condemned all those statements. So it's our position that justice is an emotional appeal to the jury to render a verdict that's not based on proof beyond a reasonable doubt. Everybody has justice is kind of a subjective viewpoint, certainly not defined for the jury, and it may be different for jurors on the jury panel. Justice may be different than proof beyond a reasonable doubt.
Suggesting that any time the state uses the word justice in its closing argument, it's per se error or reversible?
I think when they ask for when they connect the verdict and you need to, justice is 4 verdicts of guilty. I think now they're asking the jury to base their decision on justice. So I think that's when it's improper. I think that's a fair reading of Cardona, and it reduces the state's burden of proof.
And Cardona, was the reference to justice initially, that was not in the rebuttal closing, but in the primary closing. Is that correct?
I think that's correct, Your Honor.
Okay, and it was kind of a repeated statement, repeated. Obviously, the word was repeated many times in the closing. Arguably, it became a feature of the closing. Would you agree or not?
I would agree that there was more instances of the justice term in Cardona than in our case.
In our case, the reference to justice was it just the rebuttal?
It was the last 2 sentences of rebuttal. So I'd suggest it's the last thing the jury heard that makes it more prejudicial.
Okay.
Additionally, the state commented on Mr. Gonzalez's right to remain silent and shifted the burden of proof by repeatedly advising the jury that he never denied these allegations when he was talking to the detective, and never provided the defense to the detective that he raised at trial. It's our position it's an improper comment on a right to remain silent and improperly shifted the burden of proof to the defendant. The case law is clear that the right to remain silent applies to pre-arrest, pre-Miranda statements to non-law enforcement officers. The Hoggins and the Cowan case, as well as the Horowitz case in 2016.
Mr. Pinnell, what of the argument that the state really wasn't commenting on his silence? It was more analyzing what he did say and saying that's not a denial, and analyzing the next comment about, people take this kind of stuff to their grave and saying that's hardly a denial.
So if you look at the Cowan case from the 4th DCA, I think they address this pretty well. They say they just draw a distinction between voluntary and culpatory comments of a defendant, which clearly can be commented on and introduced to the jury, as opposed to absence of things that are said by a defendant. And they say that's not admissible. And in that case, the defendant was in the back seat with a co-defendant, and the co-defendant supposedly said, "Do you think they got us caught on burglary?" And the state commented on Mr. Cowan's failure to respond to that and failed to say, "I don't know what you're talking about." And they said that was improper. So the state's certainly allowed to introduce the statements he made, but they cannot introduce what he failed to say. And that's the comment on the right to remain silent. And that's the time where the state is suggesting to the jury that the defendant has some burden of proof to prove his innocence, which we know is not the case, and which this court clearly indicated in the Morris decision. So it's our position that closing argument was improper and either constituted fundamental error or should have been objected to by trial counsel. And I'll reserve the rest of my time for rebuttal.
Okay. And Ms. Davenport. You may proceed, Ms. Davenport. I think you're on mute right now. Still, yep, we still
Still
can't.
on mute, yeah.
You want to dial back in?
Button.
There we
There
go.
you go.
Can you hear me now? Okay,
Yes.
there we go.
Yeah.
My little unmute thing didn't work. I'm sorry about that. May it please the court, my name is Chris Davenport and I represent the state of Florida here. First of all, let me say that this was not a close case. The victim revealed this abuse to her mother when she was 3 years old in a way that the mom was unable to tell exactly what she said, but she said, "The defendant's touching me," and pointed to her private area. The mother remembered that. The victim remembered that. The defendant denied that. But this isn't a case where the victim just came out of the blue 14 years after this happened and had never mentioned it before. The mother specifically remembered that incident when she was 3 years old. So it's not a close case. There's also a controlled call here where the victim, called the defendant. It was on tape. It was played for the jury. The victim said, you touched me, you licked me, you claimed you were cleaning me. And the defendant said, there are certain things you take to your grave. So that's certainly an incriminating statement. This is not a he said, she said 14 years later, as defense counsel portrays on appeal. As to the Mike statement during his interview with police, I think when you read that in the full context, they've been talking about Mike for a little bit before that came up. I listened to the tape. It sounded like Mike to me. I think the most valuable part of this is the officer who was there while this was happening, heard the interview, if the defendant had said, "That's when I got caught sleeping with the little girl," I can't imagine an interrogating officer would switch the subject back to somebody else. That's just inconceivable. And I think that's the best evidence of what was actually said, because that officer was there in person and that's what the officer heard. As far as the closing argument, there is no case that says a prosecutor can't use the word justice. And I would hope that this court would not be the first to create such a case. The Cardona case is completely distinguishable. There were 58 objections during the closing argument in that case. And by the way, that claim was preserved. It wasn't being used as fundamental error. Justice for the victim is a whole lot different from justice in this case is a guilty verdict. Also, I would note the True Hill case, which is cited in my brief. was a year later by the Florida Supreme Court. It was an isolated comment that was worse than this one, seeking justice for the victim again. That was preserved below. They raised an objection and they said that that did not warrant reversal. So at worst, we have isolated, unpreserved comments here. It certainly didn't rise to the level of fundamental error. As far as the shifting the burden of proof and the comment on silence, I think the law is clear that pre-arrest silence is a lot different than post-arrest silence, but most importantly, the defendant here was not silent. They commented on what he said to the victim during the controlled call. That's not silence. When you look at what the prosecutor said, she said, taking something to your grave is a warning. It's not a denial. And a warning is an odd response from an innocent person to an accusation of sexual abuse. That's what she said. I think that's completely proper to comment on what he said and what he said to the police, where he denied that he had talked to the victim about this and then changed his story a little later. She commented on what he said, not on his silence. It was all pre-arrest. The controlled call was made to a non-governmental person. It was made to the victim, not to the police officer. The later statement, again, pre-arrest, pre-Miranda, the defendant was never told he had the right to remain silent, and it wouldn't be used against him. That changes everything once they're told that. This was all pre-arrest comments on what he said, and we would submit that's not error, let alone fundamental error. If the court has no other questions, we would ask you to affirm. Thank you.
Thank you. And Mr. Pennell, you've got a little over 4.5 minutes.
Sure. May it please the court. We don't have to guess whether this is a closed case. We know there was a mistrial because we had a hung jury. So I disagree with the state on that. Additionally, the idea that there's a distinction between pre-arrest and post-arrest silence, I think was eliminated in Horowitz in 2016 by the Florida Supreme Court, where the court said use of a defendant's pre-arrest, pre-Miranda silence as substantive evidence is prohibited. That was confirmed in the Howard case from the second DCA that the state filed as supplemental authority, where they say, taken together, Hoggins and Horowitz establish a defendant's pre-arrest, pre-Miranda silence may not be used as substantive evidence. So it's our position that certainly they can introduce any statements the defendant makes, but to point out what statements he did not make constitutes a comment on the right to remain silent, violates the Florida Constitution under Horowitz, and Horowitz says it also violates the rules of evidence in Florida. And it's our position it shifts the burden of proof in this case. And because this was a closed case, it's our position that reversal is required. Finally,
Are you saying that every time there's a mistrial, the next time it's tried, it's a closed case? I mean, that just doesn't necessarily follow. The evidence may not have been presented well in the first case. The jury may have been sleeping through it. Who knows? I mean, I don't think one necessarily follows the other, does it?
I respectfully disagree. It's some evidence that one jury panel found it to be a closed case. It's some objective evidence that we have here. The same allegations were tried to a jury and they weren't able to come to a unanimous verdict.
If you look just at the evidence presented in this case, this is unusual for a later accusation, if you will, since there was proof from the victim and her mother that she made this comment when she was 3, when most people aren't that articulate. And then when she made it later at the age of 17, I think it was, whatever her age was, she and her mother both remembered that she had made the comment at age 3. So, I mean, it's quite different than somebody at age 15 or 16 for the first time mentioning something. You'd agree with that, wouldn't you?
I would, and that, of course, that assumes that they're telling the truth, and that's what the issue is in the case. Or the mom.
Well, that's for the jury. That's always for the jury.
No, I know, but I don't think that makes it a strong case when we have a credibility contest between the defendant and the mom and the alleged victim. So this court in I think it's Romero says, even if there's ample evidence, you can show prejudice in a 3850 case. I don't think there's ample evidence in this case. And I respectfully disagree that, we often look at, did the jury have questions? Did the jury take a long time to deliberate? We look at external factors to determine whether it was a close case. And we have evidence here that the first time this was tried, there was a mistrial because there was a hung jury. So finally, I suggest that the state improperly referenced its charging decision by pointing out that the state makes the charging decision, not the victim. This court has criticized that. The federal courts have criticized that. That puts an imprimatur of the state, and they're vouching for the credibility of the case, and this court has found that to be improper. So cumulatively, we believe all the errors in this case deprive Mr. Gonzalez of a fair trial, and we ask the court to reverse. Thank you.
And thank you, counsel, for your arguments. And with that, we are adjourned.
Thank you.